Good morning, everyone. Let's get started. We are going to get started with our program on COVID-era wage and hour basics for employment lawyers who don't do wage and hour law. I'm Ramit Mizrahi from the LA County Bar Association Labor and Employment Law section, where we put on these wonderful breakfast programs for all of you, taking it virtual via Zoom. So thank you for coming, and with that, I'll turn it over to Deborah Sachs.
Sorry about that. Good morning, everyone. I want to welcome you to the program on behalf of JAMS, which has a distinguished nationwide panel of neutrals who arbitrate and mediate disputes of all kinds, including wage and hour disputes. JAMS is happy to be working together with the Labor and Employment section of the LA County Bar to bring this program to you today. For those of you who don't know me, I'm a neutral at JAMS. My name is Deborah Sachs. I mediate and arbitrate employment law disputes of all kinds. My home base is here in Los Angeles. Before becoming a full-time neutral, I practiced employment law at national and international law firms for more than 30 years. And during the last 5 or 6 years of my practice, I did almost nothing but litigate wage and hour class actions. It's no surprise to anyone that I regularly mediate and arbitrate those kind of cases now. I'm going to turn the program over to Darren to introduce himself, and then he'll turn the program over to Chris to introduce himself.
Good morning, everybody. This is Darren Cohen. I've been practicing employment law pretty much exclusively since 2002 after I graduated from law school and took the bar. I've really been focusing on wage and hour issues, individual and class action together, and have had a pretty successful career so far doing employment law. It's a really exciting area. It's really interesting, and it's an area that has very specific rules, and I'm excited today to talk about this.
Good morning. My name is Chris Jallian. I'm a senior associate with Paul Hastings, where I've practiced employment law for almost 10 years now. For much of that time, my focus has been providing employers with wage and hour advice and defending employers in wage and hour litigation, including both PAGA, class, and collective actions. My clients include financial institutions, manufacturers, hotels and hotel management companies, medical facilities, and entertainment companies. Very happy to be here today, and I'm glad I could be a speaker to speak on this topic, which I find very exciting, particularly now in the COVID era.
Thank you. I'm going to provide a high-level overview now of wage and hour law. This is wage and hour law in 5 minutes, so obviously it's very high level. After that, Darren's going to talk about the violations that we most often see in litigation, and then Chris is going to speak about misclassification cases, which we also actually see quite a lot. I'm then going to speak about class arbitration, after which Darren and Chris are going to speak about PAGA. So we have a lot to cover in 1 hour, but here we go. The first thing to know about wage and hour law is that there are federal laws and there are California laws. You have materials, you have handout materials. Each of you has a link to the handouts, which identify all of those, all of the laws I think that matter to us here. Feel free to take a look at them as we're speaking. But the idea that there are federal and state laws on the same subject is not foreign to those of you who practice employment discrimination law, where there's Title VII, the ADA, et cetera, and then there are California parallels. In the wage and hour arena, we have the federal law, which is the Fair Labor Standards Act, and CFRs that go with it, Code of Federal Regulations, extensive regulations. They're very, very detailed, and they're set out at 29 CFR 500 and following. There's a lot of them. Not surprisingly, we don't pay a whole lot of attention to federal law here because California law is much better for employees. The people that Chris counsels, the employers, have to pay attention to federal law. They have to make sure they're complying with both because they are part of the nation as well as part of California. But for plaintiffs' lawyers, mostly the California law is what they care about because that's much better for employees. than the federal law is. So what is in California law? What do we look at? There's a minimum wage order, first of all, which sets out the California minimum wage. The federal minimum wage is still $7.25 an hour. It's been the same since 2009. In California, we have a better minimum wage, which is $13 an hour if an employer has 26 or more employees, which is most employers. There are also wage orders in California. They were put together some time ago. I think the last edition was 2001 by something called the Industrial Welfare Commission, which no longer exists and therefore can never modify them. And so they're there. They've been there for a long time, and there are 17 of them. And they are applicable, each one is applicable to a different group of employees. There is one for the transportation industry. So if you are an employer in the transportation industry, that's what applies to you. There's one for the mercantile industry. So if you are a retailer, that's the one that applies to you. And there's also a general one for professional employees, that's wage order 4. So there's a bunch of wage orders. They have to be posted at the work site. And they set out a lot of stuff. In the Fair Labor Standards Act, it's mostly about minimum wage and overtime. In the wage orders, you've got a lot more interest in things like meal breaks and rest breaks and suitable seating and record keeping. That's where you find these. If you are listening and you are an employer or you represent an employer, make sure this thing is posted at the workplace. Sometimes they're posted almost on the ceiling. I've seen them in restaurants where they cook, and they're way up high. Nobody could possibly read them, but I don't think the rule is that they have to be readable. They have to be posted. And so make sure that your employers are posting these things. The minimum wage in California, I told you it's more. The overtime rules are also better for employees here. It's not just 1.5 times the regular rate for hours worked over 40 in a week here. It's also 1.5 times the regular rate of pay for all hours worked over 8 in a day here, up to the hour 12, and over 12, it's double time. And so in federal, there's no such thing as double time. It's 1.5, that's it. There's also special rules here for work on the 7th consecutive day of work. Over 8 on that day is double time, and over 8 on that day is time and a half. And I'm sorry, for the first 8 hours on the 7th consecutive day, it's time and a half. Over 8 on the 7th consecutive day, it's double time. Anyway, they're complicated rules, but that's where you'll find them, is in the wage orders. And then there is the California Labor Code. There's of course, a lot of different topics covered there. Again, meal breaks, there's duplicate meal break rules there, but there's no rest break rules there. All the rest break rules are in the wage orders. And there are rules in the Labor Code about wage statements and pay stubs and final paychecks and when they're due for terminating employees, and so on. Also in the Labor Code, we have the Private Attorney General's Act, which is Private Attorneys General Act, which is PAGA, otherwise known as PAGA. It's a part of the Labor Code that allows for non-class action, representative actions by employees against employers for civil penalties. That's a lot to say, but civil penalties are different than statutory penalties. They're things that ordinarily can only be collected by the government, like the labor commissioner. The labor commissioner doesn't do it here in California because they don't have any money to do it. So we have PAGA, and PAGA allows employees to go sue employers for things that otherwise could only be recovered by the government. That's basically what PAGA is about. That's why it's there. It's because the state doesn't have money to enforce the labor laws, so they allow employees to do it. We're going to have a section on PAGA in just a little bit, but you'll find it in the Labor Code if you're looking for it. With that, I'm going to turn the program over to Darren, who's going to talk about the common violations.
Thanks, Debbie. So let me start off here by saying that the Labor Code is riddled with a lot of information and very specific rules to California that you may not find anywhere else. And it could be a trap for the unwary For the plaintiff's bar, it's a good thing because there are a lot of issues that we can spot and help employees recover unpaid wages. And it's a very specific, I guess, opportunity to look for violations that the employer may be committing. And I know that Debbie had outlined kind of what the overtime rules are, so I won't go back through those, but I will tell you that California is very specific regarding overtime. And the rule basically in California is if you're suffered or permitted to work, the employer has to pay that overtime. So the employer can't kind of turn a shoulder and say, oh, you know, you're working past 5 o'clock, but you're not on the clock, so I'm not going to pay you. It doesn't work that way. If the employees ever suffer or permitted, the employer must pay the overtime. Even, it goes as far as saying, even if the overtime is not authorized, the employee is still entitled to that. So the rule where people sometimes say, well, you know, employer says, oh, I didn't authorize you to work the overtime, that's not sufficient. It's not a defense. The employee must be paid the overtime. The other thing that's kind of important that comes up a lot that we'll see is something called an alternative workweek election. And what you'll see is sometimes employers say, we're going to move to a 4-10 work week. And in order to avoid overtime, we're going to work 4 10-hour days and you're just going to pay you 40 hours for the week. Well, that may be sufficient under California law, but the alternative workweek election has very specific rules that are outlined in the wage orders. There must be a ballot, there must be actually a secret ballot, and there must be a count, it must be posted. And then once that has been approved by the employees, it must be filed with the Department of Industrial Relations. So sometimes we see cases where you'll have an employee call up and say, hey, I'm working this alternative work week and I'm not getting paid overtime. And then the employer says, well, no, we have an alternative work week election. Well, it's not the case unless it's gone through the proper channels. So it's something to be kind of be looking out for. Another issue we see a lot with this overtime is, you know, employees working off the clock. So in California, employees must be paid for all hours worked. There's really no exception for that. Frequently, we see a lot of employees who are working either before or after a scheduled shift. It could be pre-shift meetings. It could be post-shift closing out. We see a lot of things in the restaurant industry, where you have employees who clock out at the end of their shift. They'll print out their paperwork and they have to do their accounts. They have to do their tips and everything off the clock, and they're not getting paid for that time. So all that time should be paid for. And if you see a situation where you've got an employee working off the clock, it's a really big violation because you've got an unpaid wage claim and some other things we'll get into later. Some of these other issues with off the clock could also be a result of the employer's poor timekeeping. A lot of times you'll see employers who have timesheets and you'll see employees put specific times down and then you'll see the employer come through and round the time, which is unlawful. Rounding in California can be considered a valid option for an employer as long as it's valid and neutral. A lot of times you'll see employers just rounding the time to the quarter hour without looking at how the time works, and that's a violation under California law as well. Now, looking into overtime, something that pops up frequently that you'll see is a regular rate issue. So as Debbie said earlier, when you talk about overtime, it's the regular rate of pay. So what that means, if somebody's getting paid, for example, $10 per hour and they work an hour of overtime, when obviously they'd be entitled to $15 per hour. But in California, you have to also include additional compensation into the regular rate of pay. So what I mean by that is if you've got a situation where you've got some kind of additional compensation, whether it be a bonus, whether it be a shift differential, whether it be a production-based incentive, all of that compensation has to be considered into the regular rate of pay for overtime purposes. Now, this gets very complicated with the calculations. It's difficult to go through, but I just kind of want you guys to be aware that there's these issues where this additional compensation has to be included in the regular rate of pay. And that includes non-discretionary bonuses or non-discretionary income. And what that means is something that's tied to a metric. So like I said before, if it's a shift differential, if it's a commission, if it's a flat sum bonus or production-based incentive, something that you can track or something that there's a goal set, that compensation is considered non-discretionary and has to be included in the regular rate of calculation. If you have a situation regarding a discretionary bonus where it's something like a holiday bonus or a gift, that does not need to be considered into the regular rate of pay, and that can be excluded for the purposes of calculating overtime. And again, as I said before, these are complicated issues. There are a lot of cases that talk about this, how to calculate this regular rate of pay. I would highly recommend if you see something on a pay stub or you see something you're talking with a client regarding this additional compensation, that you kind of research the issue. You can look into the wage orders. You can also look into some cases that are very specific. And I think that's in some of the materials that we provided. Now, shifting gears and talking about meal periods, this is something that's very, very, very common in California. We've got very specific rules. And I'm just going to do a real high level meal period kind of evaluation. But in California, basically, you're talking about employees who work more than 5 hours a day. They're entitled to a full 30-minute uninterrupted meal period. Now, if the employee works a shift less than 6 hours, then the employee may agree to waive that meal period. So, for example, if the employee is working a shift and it's going to be 5.5 hours, then the 30-minute meal break may be waived by the employee, so the employee doesn't have to stay for the extra 30 minutes and go home. They can just go home at the end of the shift. If the employee works more than 10 hours per day, then they must be given a second 30-minute meal period. And again, there's a strange rule with this where the employee can waive the second meal period if the shift is not longer than 12 hours and the employee didn't waive the first meal period. That's kind of the basic framework for the meal period rules. Now, the thing that's really important here that you'll see a lot is that employees should be clocked out for the 30 minutes and relieved of all duty and not interrupted. So a lot of times you'll see employees or the employers who's not tracking the meal period, they're not clocking employees in and out. That's two problems. Number one, there's no way to ensure that the employee got a full 30 minutes. And number two, it doesn't satisfy the timing requirements, because if the meal period is supposed to be received by the employee, it must be taken before the end of the 5th hour of work. So without those records, it's almost impossible to tell, and it seems to be a meal period violation for the employer. It's also really important that the employer has an affirmative obligation to make the meal periods available to the employee. They don't necessarily have to police the employee, but they have to make it available. They can't stop the employee from taking it or kind of dissuade them from doing that. Another thing that we see commonly is we see that the employers have a kind of restriction and say the employee can't leave the premises during a meal period. Even if the employee gets a full 30 minutes, but they're not allowed to leave the premises, that is a meal period violation. These are very specific rules. There's a lot of minutia, unfortunately, with the meal periods. And again, there's a lot of case law on this. The wage orders do a really good job of kind of outlining the rules. But it's something to be aware of, that if you ever hear of an employee saying they're not taking a 30-minute meal break or they're not getting a lunch period, something to flag and keep an eye out for. Something that also comes up frequently is an on-duty meal period agreement. And what that means is that if the employer has a type of a situation or a job where the employee and the nature of the work can't be relieved from all duty, then they can have something called an on-duty meal period agreement, which is something that is signed by the employee and the employer. And it provides that the employee will receive an on-the-job meal period. And this is something that you'll see very frequently where employers try to have employees sign these agreements, but they're not applicable. It really has to do with the situation. We've got like a remote worker at a kiosk or a security guard working at a shift where there's no relief. So you'll see a lot of times employers trying to get these on-duty meal period agreements signed by employees when they're not applicable. And if there's an agreement that's in place and it doesn't apply, then the employee is entitled to that meal period penalty. And the last thing I'll say about the meal periods real quick is that the employee must be paid at the regular rate of pay for these violations. So if there's a meal period that's missed, they're entitled to receive 1 hour of compensation at the regular rate of pay. So now kind of switching gears into going into rest periods. California law is very specific about rest periods as well, just like meal periods. You're entitled to a 10-minute rest period every 4 hours or major fraction thereof in the workday. And the key issue here is the major fraction thereof. So if you work a shift at least 3.5 hours a day, you're entitled to 1 rest break. If you work over 6 hours, you're entitled to a 2nd rest break. If you work over 10 hours, you're entitled to a 3rd rest break. And these rules are very specific. Sometimes you'll see employers say, oh, you're gonna get 1 10-minute break, or you'll get 1 20-minute break. But the rule is you're entitled to these 10-minute breaks, and they're supposed to be scheduled as practical in the middle of the work period. And if the employer does not provide this time, then the employee is entitled to a 1 hour penalty for a rest period. And this time that we're talking about, which is different than a meal period, is the rest period is on the clock, meaning the employee does not clock out. It must be counted as time worked. And the same with the meal period, they must be allowed to leave the premises. Keeping an employee on the premises for a rest break is a violation as well. A couple two side notes I'll say is that if you've got an employee who's working less than a 3.5 hour shift, there's no rest period requirement. And also, this is something that comes up, and it's a little bit complicated, but something you should be aware of is that if you have an employee paid on a piece rate basis, they must be paid for their rest period time separately. So for example, if you have an employee who's getting paid, I don't know, let's say $10 per piece if they're a roofer, for example, well, then the employer must pay the employee separate compensation for the rest period time. And there's some cases that really dive into this, and I'll just mention the name here. It's Blueford versus Safeway Stores. And it gets very complicated in the calculations, but basically, you basically have to take the time that they work per week, figure out how many hours. So for example, in a 40-hour work week, they'd be owed 1.667 hours of compensation for the rest period, even though they're paid on a piece rate. Kind of moving along here, trying to get through a lot of this stuff, unfortunately, is reimbursement expenses. This is kind of a hot topic in COVID right now. Labor Code Section 2002 does a pretty good job of laying out that the employee must be reimbursed for all necessary expenditures incurred by the employee in the discharge of their duties. A lot of times you'll see situations where you've got cell phones, you've got personal vehicles, you've got tools, you've got uniforms, and the employer is trying to pass the cost on to the employee. It's unlawful. The employer has to reimburse those employees. The only thing I'll say that I kind of gloss over real fast is with tools and equipment, if the employee is making at least 2 times the state minimum wage, then there's no requirement that the employer has to reimburse for the tools for work. But in other situations regarding like personal vehicles and cell phones and uniforms, those costs have to be borne by the employer and not by the employee. And especially with COVID now and working from home, you may have some issues regarding internet, paper, toner, things that you would normally get in an office that the employee now has to pay for from their home. That should be reimbursed expenses as well. Moving on to here to reporting time pay, you've got situations where if you have an employee who shows up to work for a scheduled shift and they're sent home, whether it be a lack of work or they just schedule too many people, well, the employee then is entitled to at least half their scheduled shift, which is a minimum of 2 hours and a maximum of 4 hours at the regular rate of pay. This is also, it doesn't apply to an employee who's on standby or has a shift less than 2 hours, but if the employer comes to work and they're ready to go and the employer sends them home, there's a reporting time pay violation. They'd be entitled to get paid for those 2 hours or maximum 4 hours of their shift at the regular rate of pay. Moving on to wage statements and pay stubs, this is really a hot topic in California law. There's very, very strict requirements. Labor Code Section 226A lists 9 very specific requirements that must be shown on the pay stub, and I'll just kind of go through them quickly here. Must have gross wages earned, must have total hours worked by the employee, must have the number of piece rate units earned and all applicable piece rate if the employee is paid on a piece rate basis, must state all deductions provided, must have the net wages earned, must have the inclusive dates of the period for which the employee is paid, must have the name of the employee and only the last 4 digits of their social security number or an employee identification number, has the name and address of the legal entity, that's the employer, and also has all applicable hourly rates in effect during the pay period and the corresponding number of hours worked at each hourly rate. Now again, this is a really specific requirement that you'll see in the labor code, and you'll see this is riddled in kind of California where employers just make a mistake and they completely err and they just forget to include some key information. And that leads itself to a pay stub violation. And in California, it's $50 for the first violation. It's $100 for each subsequent violation per pay period per employee. And it's not to exceed at $4,000 per employee in total. But these penalties seem to, escalate very quickly, especially in a large workforce. They're also entitled to recover attorney's fees and costs if there's a pay stub violation. Now, the labor code does a really good job of describing this in detail. There's some injury requirement that's outlined in the statute, but the injury requirement is presumed if the employer fails to provide the information that I just described before in the 1 through 9. There's a lot of case law regarding what is an injury, what is a reasonable person standard. I would just tell you here as a high level kind of evaluation, if the pay stub by itself does not provide the information that's required, and you have to look at another document or another piece of information to determine what the statute's required there to be on the pay stub, then that would be an injury and that would entitle the employee to a penalty. Kind of moving into the next phase is payroll timing issues. You'll see this in California very specifically. Excuse me, Labor Code Section 204 outlines when the employee must be paid. There's a couple different ways that employees can get paid. There's bi-monthly, which talks about an employee gets paid between the 1st and the 15th, and then the 16th and the end of the month. So 2 pay periods per month. If the employee is paid between the 1st and the 15th, then those wages must be paid by the 26th of that month. And if there's work that happens between the 16th and the end of the month, then that must be paid by the 10th of the following month. So if the employer pays the employee, let's say, from the 1st to the 15th on the 27th or the 28th, that'd be a violation. Or for example, if it's between the 16th end of the month and they're paid after the 10th, that would be a violation as well. Now, where the rules get a little bit more tricky is when you're talking about an employee who's paid bi-weekly, which is every 2 weeks. So if the employee is paid every 2 weeks, they must be paid no later than 7 days after the close of the payroll period. So if you've got a payroll period that happens, let's say, every other Friday, then it has to be paid within the next Friday. You can't wait. You'll see this frequently where employers are waiting 10 days or even more to pay their employees. That's unlawful under California law. Same rules apply when you have a bi-weekly payroll period, would be a weekly payroll period. So if you have an employee's paid every week, those have to be paid 7 days at the close of the payroll period. And again, these penalties kind of apply the same way that Labor Code Section 226A applies, where you've got $100 for the first violation, $200 for each subsequent violation, plus 25% of the wages that were unlawfully withheld. So this obviously, just like 226A penalties, can escalate very quickly depending on the number of employees you have and the number of payroll periods that are stacking up. Moving in kind of the last situation here that we're kind of isolated as a situation that's very common in California is Labor Code Section 203, which deals with the final paychecks. So in California, you've got a situation where if the employer terminates an employee, they must be paid immediately upon termination. You cannot wait. So a lot of times you'll see employers terminate an employee and say, oh, come pick up your paycheck the next pay period, or you'll see them say, come pick it up the next day. It's unlawful. Employees must be paid their wages immediately upon termination. If the employee quits without notice, the rules are a little bit different. The employer then has 72 hours to pay the employee. Now, the key issue here is that the employer has to make the wages available, meaning that if the employer says you're terminated, and the employer says, well, I don't want to stick around and wait for my paycheck, I'll just mail it to me. Well, that might alleviate the 203 penalty on behalf of the employer. But these rules are very specific, and the penalty is that it's a daily wage for up to 30 days. So you can see a situation where if you don't pay the employee, let's say they're $80 if they're getting paid $10 an hour for the day that they worked, it could quickly escalate into a large penalty. It could be, thousands of dollars in 203 penalties per employee. The penalty here won't apply if there's a good faith dispute regarding the wages owed. So if there's a regular rate issue or there's an outstanding commission or something that's in dispute between the parties, the employer may be able to say there's a good faith dispute if the parties are working in time to resolution and try and get the employee paid. But these penalties are pretty strictly enforced, especially by the labor board and by the courts. If you've got unpaid wages that are due at the end of the employee's pay period, or at the end of their employee, then they need to be paid immediately. You cannot wait. The last thing I'll kind of say regarding these 203 penalties, as are commonly referred to, is you've got an employment relationship that ends, the penalties will apply. So layoffs are included, especially in COVID. If you lay some employees off and you don't pay them immediately upon that layoff, that's a 203 violation. And also if you've got a situation where you've got a staffing company, this happens very frequently, where you've got a staffing company who assigns someone to work at, let's say, company A, and then that period ends, and now they're kind of done with that job and they're going to be moved on to a different job. That wouldn't trigger a 203 penalty because it's a staffing company and they're still employed by the staffing company, even though that, assignment ended at that company. So staffing companies have a little bit of a leeway as to when they would have to pay their final wages, only when they terminate that employee. And with that being said, I'll move it over to Chris and he can talk about the next issues.
Thank you, Darren. The word classification or misclassification are often thrown around in the employment law and wage and hour context, but there are actually two categories of classification that we often see being litigated. The first is when an individual is classified as an independent contractor, but that individual is actually an employee. And An independent contractor is a person or an entity contracted to perform work or provide services as a non-employee. Think like a plumber that you might hire to fix a leak in your home. Typically, independent contractors are thought to be self-employed with great freedoms relating to their hours and clients and paying their own taxes. The second type of classification litigation is brought by employees that are exempt from overtime laws. These employees are commonly referred to as exempt employees, alleging that they should have been classified as non-exempt employees and paid an hourly wage for all hours worked as opposed to a fixed salary. Cases challenging employment classification, they're often referred to as misclassification cases, and they can be brought either on an individual or class action or even a PAGA basis. Recently, misclassification has been a very hot topic, and I expect the litigation of misclassification cases to actually increase as a result of the COVID-related work from home and other challenges, which I'll get into in a minute. But let's take each of these categories of classification in turn, beginning with the independent contractors. There's been an uptick in independent contractor misclassification cases as a result of Dynamics Operations West versus Superior Court, a recent California Supreme Court case which completely overhauled the test that we use to determine whether someone is an independent contractor, and AB5, which codified Dynamics. And I'll touch on both of these tests in a minute. And that uptick I referred to in cases, I actually expect that to continue and be accelerated by the COVID pandemic and related fallout, because there are likely many independent contractors right now completely out of work, such as construction workers, cleaners, tutors, gig workers, certain app workers. And these independent contractors are at home. They don't have the protections that are afforded to traditional employees under the labor code, or protections such as healthcare benefits, vacation time, and unemployment. Similarly, with the financial impact that the COVID pandemic may cause, employers may turn to independent contractors as a means of restructuring the costs of doing business, which would mean more independent contractors being used in the state. There is no misclassified cause of action. So a plaintiff alleging they were misclassified typically would claim that they were deprived of the protections of the labor code. And going back to what Darren was talking about, they would allege, for example, that they didn't receive their minimum wage or overtime pay, that they didn't receive meal or rest breaks. One note on meal and rest break issues: there is no attorney's fees recovery for plaintiff's counsel in meal and rest break cases, as affirmed by the recent decision in Betancourt versus OS Restaurant Services, LLC. Employees, independent contractors alleging they were misclassified will also claim that they didn't receive any wage statements and that they weren't reimbursed for necessary business expenses. The exposure for these claims could add up very quickly when considering that an independent contractor likely will allege one or more of these labor code violations took place each day or each pay period. Misclassification can carry other serious consequences as well, and I won't get into them all here, but you could have issues with the IRS or state taxation authorities regarding unpaid payroll taxes or other employment-related taxes. Also, it's important to note that the law and not the party's written agreement controls whether a worker is an independent contractor. In other words, an employer and an independent contractor cannot avoid a misclassification case by simply including a clause in their agreement with the worker that the worker is an independent contractor. So then how do we know whether a worker is properly classified? My favorite lawyer answer, it depends. There are multiple tests that apply in determining whether someone is an independent contractor. And these different tests apply depending on which form the case is brought in and who's challenging the classification. The IRS, for example, has a test. The National Labor Relations Board has a test. Federal law has a test. California, not to be outdone, now has 2 tests, depending on the worker's role. And so for the employers and those advising employers in this room, I would recommend that the attorney look at more than a single test to avoid liability across different forums. With the time we have, I'm only going to cover the 2 tests that I see most often litigated, and that's the federal and state test for independent contractor classification. The FLSA employs what's known as the economics realities test for determining whether an independent contractor is an employee. Under this test, courts consider and weigh several factors. The most important of these factors is the nature and degree of control by the employer. The more freedom the independent contractor has, the more likely the independent contractor is correctly classified. So questions you can ask yourself in evaluating control include who dictates how the work should be performed, who mandates what supplies are used, who undertakes quality control, who sets the rate of pay, who sets the hours. Does the employer limit the independent contractor's ability to contract with other clients? In the COVID era, plaintiffs may contend that requiring on-site testing, temperature checks, PPE, or setting forth how work should be performed to limit the spread of infectious disease could give rise to more control, more employer control, and therefore new avenues to challenge classification. From a defense perspective, I would argue that these COVID-19 limitations, first of all, are hopefully very temporary, and second, do not demonstrate the employer's control over the independent contractor's duties. Rather, it's about whether or not the independent contractor should be performing work at all. For example, if the independent contractor may have an infectious disease, he shouldn't be showing up to perform work that day at all. Other factors to consider in analyzing independent contractor misclassification under the FLSA include whether the independent contractor's services are integral to the employer's business, the amount of the independent contractor's investment in his own facilities and equipment, the independent contractor's opportunity for profit or loss, the length of the relationship between the independent contractor and the employer, and whether the contractor can work for other employers without prior approval. And I can see that issue also maybe coming under attack in the COVID era, where an employer might require an independent contractor to only contract with them, at least for a temporary basis, to protect its workforce. Federal courts consider other factors as well, which I haven't covered. The material from the DOL, which is available online for free, goes into each factor, and I recommend reviewing those before giving any advice on independent contractor classification under the FLSA. It's important to note that the Supreme Court has weighed in and said that no one single factor that I discussed is controlling with respect to the independent contractor employer relationship, and rather the circumstances must be looked at a whole. Switching gears to the California test. California courts do not employ the economics reality test. Instead, California uses a 3-part test called the ABC test, which was first adopted in Dynamics in 2018 by the California Supreme Court. Unlike the federal test, the employer is responsible for establishing each element of the test to prove that the independent contractor is properly classified. The first element the employer must demonstrate, or A, is that the contractor is free from the control and direction of the hiring entity in connection with the performance of the work. And the California Supreme Court gave an example of too much control. In their example, a retailer provided yarn, pattern, and instructions to tailors that were knitting cloth for the retailer. And according to the California Supreme Court, those retailers will fail Part A of the ABC test. The second element, or B, that the employer must establish is that the independent contractor performs work outside of the usual course of the hiring entity's business. For example, this means that a company that provides residential plumbing services and classifies all its plumbers as independent contractors will likely not be able to satisfy the second element of this test. The third element, or C, that the employer must establish is that the worker is customarily engaged in an independently established occupation or business. In other words, the contractor should be operating his own business, having his own clientele, and ability to work for other clients will help establish this element. The ABC test replaced the decades-old test known as the Borello factors for determining whether an independent contractor is correctly classified, at least under the IWC wage orders. This shakeup led to lobbying, which culminated in Assembly Bill 5, or AB 5, which codified and both expanded and limited dynamics. So AB 5, which is in Labor Code 2750.3, sets out the ABC test. And in addition, it exempts certain professions from the ABC test, meaning these professions, whether or not they are independent contractors or correctly classified as independent contractors, that is determined by the common law test in Borello and not the ABC test. And just briefly, these professions include certain licensed professionals, like think lawyers, doctors, dentists, accountants, architects, securities broker dealers, direct salespeople, certain contractors for professional services, and certain contractor, subcontractor relationships in the construction industry, and some real estate licensees. If you represent employers, I recommend that you periodically review the independent contractor classification for compliance with the ABC test, or if applicable, the Borello test. I think it's particularly important in the COVID era where we might see plaintiffs' counsel seek to challenge the classification because, as I mentioned before, there may be arguments that there is more employer control over the independent contractors. And this, now turning to the second type of classification of exempt employees. Generally speaking, exempt employees are paid on a salary basis. They don't get paid overtime, and they're excluded from California's meal and rest period laws. For that reason, an exempt employee misclassification case, plaintiffs will typically bring claims for unpaid overtime, unpaid minimum wage, meal and rest period violations, and wage statement penalties. In California, employees are presumed to be non-exempt. So again, the burden is on the employer to prove the exemption. To properly classify an employee as non-exempt, the employee must fit into one of three exemptions enumerated in the one of the exemptions enumerated in the FLSA and California law. The most common of these exemptions are the so-called white-collar exemptions, and these include the executive exemption, which covers your managers, your executives that supervise or direct the work of other employees. The administrative exemption, which includes employees that perform work directly related to management or the general business operations of the company, and that includes tax, finance, accounting, human resources, benefits, and similar activities. And the professional exemption, think lawyers, doctors, dentists, teachers. Once you've identified the relevant exemption, the next question is, what does the employer need to prove to establish that this exempt employee satisfies that exemption? Well, in California, the employer must prove at least three things. First, the exempt employee spends more than 50% of their time performing exempt duties. For example, in the case of the executive exemption, the employer would show that the manager or supervisor spends 50%, more than 50% of his time managing and delegating, as opposed to stocking shelves or cashiering, which are traditionally non-exempt duties. Second, the employer must show that the employee customarily and regularly exercises discretion and independent judgment in performing the exempt duties. An employee's judgment is typically independent when it's free from immediate direction or supervision. And third, the employee must earn at least 2 times the state minimum wage for full-time employment. In California, with minimum wage increasing every year, employers and those representing them should periodically analyze the salaries of exempt employees to make sure they satisfy this element. Also, each of these exemptions have unique criteria that must be met. For example, under the executive exemption, the employee must direct the work of 2 or more people. Under the professional exemption, the employee must be licensed or certified by the state of California in one of the recognized professions. Federal law has a different test, and under the FLSA, to be exempt, the employer must prove that the employee's primary duty is exempt work. And by primary duty, that means the employee's main or most important function or duty is an exempt function. Federal courts may look at the time the employee spends performing various functions to determine which is her primary duty. However, time alone is not determinative. An employee that spends 50% of her time on non-exempt tasks may still be exempt if the employer can establish that the primary duty is nonetheless exempt work. And employees must be paid at least $455 a week, which is far less than what California requires. Both California and federal law, wage and hour law, apply to employees working in California. Thus, an employee must satisfy both of these tests, both the California and the federal test, to be exempt. However, most of the time, the California requirements are much more restrictive. Thus, if the employer can satisfy the California requirements, then it more than likely can satisfy the FLSA requirements. However, from a defense practice standpoint, employers and those defending them should be aware that their or their clients' exempt employees should make sure that their clients' exempt employees satisfy both exemptions. Satisfying an exemption only under California law could leave the employer open to FLSA claims, such as a claim for unpaid wages. 2 other exemptions I want to touch on briefly, which I think have COVID implications. The first is the inside sales exemption, which covers employees whose total earnings are comprised of at least 50% commissions during the representative period and earn 1.5 times minimum wage for all hours worked in each work week. And the second is the outside sales exemption. Think your door-to-door salesman or someone that spends most of their time outside of the employer's place of business, which could include their own home, selling products to clients. We can't foresee the litigation that's going to arise from exempt classification during the COVID era. However, some plaintiffs' counsel may argue that work from home or the various stay-at-home orders change the scope of the work performed, resulting in an employee spending less than 50% of the time on exempt duties. For example, reduced staffing in the COVID era may affect some employees classified as exempt under the executive exemption. As an employer, you should look to see if your executive employees are performing their expected job duties, like supervising 2 or more employees, and not spending their time on non-exempt work. Similarly, work from home orders may impact outside sales employees because these employees, at least temporarily, are required to work from a fixed location, such as their home. An interesting question to consider is whether a sales Zoom meeting could qualify as outside sales activity, allowing these outside sales employees to retain their exemption. Last, commission sales employees may see a reduction in their commissions as a result of reduced sales. So employers should keep an eye on these employee sales activities, and if necessary, consider adjusting the commission percentage to retain the exemption. Overall, I think it's important for employers to reinforce their expectations regarding exempt duties and to keep an eye on the actual duties being performed by their employees during the COVID era. If it's no longer feasible for an employee to carry out her exempt functions during the COVID era, employers should consider reclassification. Employers can reclassify an exempt employee at any time, and the sooner an exempt employee is reclassified, the less exposure there might be from a potential misclassification lawsuit. With that, I'm going to turn it back over to Debbie to speak about class actions and class action waivers.
So in this arena, class actions are really scary to employers. Some of the damages or wages owed, depending on what you call the remedies for these violations, are small on a per person basis. But if you can accumulate hundreds of employees in a class action, it's a totally different animal. And also, of course, there's attorney's fees that come with these kinds of actions. So they're attractive to the plaintiff's bar. What's happened recently in the last 10 years is employers have gotten smart about arbitration agreements. And many employers require employees to sign arbitration agreements as a condition of employment. They're called mandatory arbitration agreements. That's what I would call them. That's what I will call them as we talk today. In thinking about whether class arbitration or class actions are permitted, it's important, of course, to look at the language of the arbitration agreement. I have seen arbitration agreements that say everything, including class actions, go to arbitration. They're very rare. I had one. As an arbitrator, I arbitrated a class action because that's what the arbitration agreement said. Most arbitration agreements for many years have said just the opposite, which is there's no class arbitration permitted. What that means is that the employee can't have a class action anywhere. They can't have a class action in court because they've agreed that all their claims go to arbitration. They can't have a class action in arbitration because they've agreed that there's no class arbitration, so they're stuck. In California, there was a case called Discover Bank, California Supreme Court, 2005, where our Supreme Court said that's unconscionable. You can't have a situation where you can't have a class action anywhere. And so if an arbitration agreement says no class arbitration, it's unconscionable and we will not enforce it. That was the law here for quite a long time until Concepcion came along. There's a case that's cited in your materials. It's a U.S. Supreme Court case from several years back now, where the court said, "Oh, that Discover Bank rule, excuse me, that California Discover Bank rule, that's preempted by the Federal Arbitration Act." The decision is fairly results-oriented, in my opinion. I think that the U.S. Supreme Court thought that we should uphold these waivers. So after Discover Bank, it was clear that if a company put a provision in its arbitration agreement that says no class arbitration, a court would have to uphold it, an arbitrator would have to uphold it, and there'd be no class arbitration and there'd be no class action in court either. So that's if the arbitration agreement expressly says no class arbitration. What if it doesn't say anything? After Concepcion, there still remain many arbitration agreements that don't say anything about whether you can have a class arbitration or not. Many courts and employers in California, looking at California law, said, oh, well, under that circumstance, of course there could be class arbitration. You can't go to court because, well, it says you're going to bring all your claims in arbitration, but you can still go to arbitration because it doesn't say you can't. We think under those circumstances that would be fine. Then there's the final nail in the coffin to class actions in this arena in California is Lamps Plus, which is a very recent U.S. Supreme Court case. The U.S. Supreme Court keeps coming in and stomping down California's sensibilities on this issue. They came in and they said, well, an arbitration agreement that doesn't expressly permit class arbitration can't be interpreted to permit it. So basically, if an employer is able and willing to put in an arbitration agreement that expressly excludes class arbitration, then there'll be no class action anywhere by those employees. And if they don't actually change the arbitration agreement and it's silent, there's also no class arbitration. And so That's the state of the law here in California with respect to having these cases as class actions. I'm going to turn the panel over now to Darren, who's going to talk about PAGA and why it's so important in light of what's happened with class actions.
Thanks, Debbie. I'm going to make this kind of quick because we've got situations with PAGA that are complicated. Same with the labor code. But Labor Code Section 2699, which we refer to frequently as PAGA, or Private Attorney General Act, outlines what the requirements are in order to file a PAGA claim, and they're very specific. Labor Code Section 2699 actually provides, 2699.5 actually provides a list of the Labor Code sections that you can bring a PAGA case for. That includes things that we've talked about today: overtime, meal breaks, rest breaks, itemized wage statements, a whole litany of claims that are specifically listed. In order to do that, you have to follow a couple key steps. Number one is you have to write a letter to the employer and send it by certified mail that has enough facts and details that outlines the proposed violations. That letter also has to be uploaded onto the LWA's website, and you have to pay a $75 filing fee in order to do so. These labor code sections that we're talking about under 2699.5 are labor code sections that cannot be cured by the employer. So what that means is even if the employer takes an affirmative step, there'd still be a violation for the past wrongdoings. Once you've provided notice to the LWDA by the online system and paying the fee, there's a 65-day waiting period before a PAGA claim can be filed in a court. So that just means that 65-day period, there's a possibility that the Labor Workforce Development Agency may take the case and may investigate on their own, or they may pass and do nothing, and that's why the 65-day waiting period has to elapse before you can actually file that claim in court. It's also really important to know that once you have a claim in court, a lot of things have to happen. A copy of the complaint has to be uploaded into the LWDA's website. Any settlement that is reached between the parties has to get court approval. And again, those settlement documents must be provided to the to the LWDA through their online web portal. And any copy of any judgment or order from the court must be provided to the LWDA. These are very specific requirements. If something is missing or the letter that is sent to the defendant is not clear, it could be a precursor to bringing the claim or having the whole PAGA complaint stricken from court. So you want to make sure you follow these guidelines very specifically. That being said, I'll just say real quickly with the penalties, it's important that you recognize that the penalties are $100 for the first violation and $200 for each subsequent violation per employee. You have to remember too that 75% of this goes to the state, while 25% goes to the aggrieved employee. So while the penalties escalate really quickly, some of the money that's actually going to the employees is small. So just something to be aware of when you're looking at these cases. And that being said, I'll pass it over to Chris, who could talk more about kind of PAGA and how that applies.
Thanks, Darren. So the PAGA lawsuit's been filed, and as an employer, you have several ways of challenging it. First, if the plaintiff isn't an aggrieved employee, the suit is subject to dismissal or summary judgment. And a plaintiff isn't an aggrieved employee if she hasn't suffered the labor code violations at issue in the complaint or the PAGA letter. There's some dispute as to whether the plaintiff needs to suffer all the violations she's alleging or just one of them. And at least one California appellate court in the Huff decision has held that a plaintiff that has suffered one violation, for example, missed meal periods, can represent employees that have suffered other violations, for example, missed rest periods. But this area of law and PAGA is very popular right now. It's still developing, it's changing rapidly. So it's definitely something practitioners should keep their eyes on. Second, as Darren mentioned, if the PAGA notice to the LWDA or the employer is deficient, the defendant can demur the complaint. A PAGA notice is deficient if it doesn't have enough facts or enough information to put the LWDA or the defendant on notice as to the nature of the claims and allow the LWDA to investigate. And the notice also might be deficient if it's simply just a string of legal conclusions, parroting the language of the labor code without providing any facts as to how the labor code was actually violated. Additionally, it might be deficient if it doesn't identify the other allegedly aggrieved employees that the plaintiff may seek to represent. As Darren mentioned earlier, the PAGA statute allows a private plaintiff to recover civil penalties. And these civil penalties, they're either enumerated in the labor code for some sections. For example, labor code section 558 sets forth what penalties could be recovered for unpaid wages. Or if the labor code is silent on the recoverable penalties, then the PAGA statute provides that a plaintiff can recover civil penalties in the amount of $100 per violation for the first violation and $200 for each subsequent violation per pay period for each aggrieved employee. There's a difference of opinion between plaintiff's counsel and defense counsel as to what constitutes a subsequent violation. Defense counsel, we maintain that a subsequent violation is not triggered until a court or the LWDA rules that there is actually an initial violation. Until there is such a ruling or determination, it's our position that all penalties accrue at the initial violation rate. Darren likely disagrees with that, but I think defense counsel has some support from the labor commissioner on its position. Ultimately, whatever penalties are awarded, a court has discretion in reducing the PAGA penalties award, and defendants can seek a reduction in the award by showing that they tried to comply with the labor code, they took the labor code violations very seriously, or that the plaintiffs or the aggrieved employees suffered no harm, such as a technical violation with a pay statement. As Darren mentioned, PAGA cases, they tend to settle like all other cases. And if a PAGA case is settled, the court and the LWDA need to be provided the PAGA settlement materials so that they can both approve it. The LWDA usually just doesn't act, which is seen as a silent approval. And the courts will either approve the settlement by a motion or a stipulation for by the parties. One thing I will note is that in terms of PAGA settlement and allocating settlements to PAGA, it's wise for the parties to allocate more than a nominal sum to the PAGA penalties to secure court approval. There is no bright line rule as to how much should be allocated to PAGA. For example, in a class action settlement, how much of that should go to PAGA. But courts have rejected settlements where only 1% of the total was allocated to the PAGA case, PAGA claims. We have gone over on our time a little bit, so I would just like to thank everyone for coming, spending your morning with us, and we hope everyone stays safe. And if you have any questions, I believe we're going to have an FAQ where we answer the most popular questions.
Thanks everyone for joining the conference. I have been answering questions as we've been going along. In case you're wondering who's answering the questions, it was me. But there are some that I haven't answered, and in part because they're more complicated than you can answer in a 2-word response during a seminar. I don't know that we will get to them, but I'll get back to everyone one way or the other, either to say I can answer it or I can't.